Welcome to the Law GA channel and welcome to our special content on constitutional law principles. This lesson is divided into 3 parts, and for the purpose of this video, we are beginning with part 1. Today we are presenting to you part 1 of the laws on constitutional law interpretation in Ghana. We believe that this lesson will substantially aid you in your studies of the law on constitutional interpretation. We encourage you to read the facts of the cases we are presenting so you will be able to appreciate the principles stated in this lesson. Kindly subscribe to this channel, like our videos, and help us share our knowledge to everyone. We are grateful in advance. Let us now commence by looking at what the cases are saying about constitutional interpretation in Ghana. The first thing we'll be looking at is the difference between constitutional supremacy and parliamentary supremacy and the Ghanaian position. In the case of Justice Abdullahi and Attorney General, Justice Kulendi stated that it must be noted that the 1992 Constitution establishes constitutional supremacy as against parliamentary supremacy. Under parliamentary supremacy, as pertains in the United Kingdom, Parliament is sovereign and all laws, decisions, procedures of Parliament are final and cannot be subject to judicial review by the courts. The courts merely apply the legislation made by Parliament and may not hold an Act of Parliament to be invalid or unconstitutional. Under our current constitutional dispensation, the sovereign people of Ghana have adopted for ourselves a constitution where it is expressly declared in Clause 2 of Article 1 that the Constitution, not Parliament, shall be the supreme law of Ghana, to which all other laws must conform. To this extent, any law or act or omission found to be inconsistent with the Constitution shall, to the extent of that inconsistency, be void. To further reinforce this constitutional supremacy, the Constitution in Article 2 confers on any person who alleges that an act or omission of any person is inconsistent with any provision of the Constitution the right to apply to this court for a declaration to that effect. Also, in the case of Ghana Bar Association and Attorney General and Justice ACQUAH, it was held that under the new order of constitutional supremacy, the Constitution 1992 has vested the power of supervising and enforcement of the Constitution in the Supreme Court, the judges of which have sworn to uphold and defend its provisions without fear or favor. Parliamentary sovereignty, as practiced in Britain, is alien to our new legal order. The Constitution 1992 has vested the power of judicial review in all legislations in the Supreme Court. It has dealt away with either an executive or parliamentary sovereignty and subordinated all the arms of organs of the states, the Constitution. The court, as the repository and watchdog of the Constitution 1992, is enjoined to protect, defend, and enforce its provisions and should not allow itself to be diverted to act as an independent arbiter of the Constitution 1992. The second thing we'll look at is the jurisdiction of the Supreme Court, that is the enforcement and interpretive jurisdiction. Clause 1 of Article 2, Constitution 1992. A person who alleges that A. An enactment or anything contained in or done under the authority of that, or any other enactment, or B. Any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. 2. The Supreme Court shall, for the purpose of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declarations so made. Clause 1 of Article 130 of the Constitution 1992, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms, as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in A. All matters relating to the enforcement or interpretation of this Constitution, And B, all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law or under this Constitution. In Ghana Bar Association and Attorney General, Justice Pega, as he then was, affirmed the position in Bedema and Abuna Williams, where the court first laid down the circumstances in which one may base on to invoke the exclusive original jurisdiction of the Supreme Court. 1/4 for a quarter for a plaintiff to be able to invoke the original and exclusive jurisdiction of the Supreme Court. His writ of summons and or the statement of claim must prima facie raise an issue relating to 1. The enforcement of a provision of the Constitution, or 2. The interpretation of a provision of the Constitution, or 3. A question whether an enactment was made ultra vires Parliament or any authority or person by law or under the Constitution. The third thing we'll be looking at in this video is the capacity to invoke the exclusive original jurisdiction of the Supreme Court under Clause 1 of Article 2 of the Constitution 1992. In the case of Sam No. 2 and Attorney General, Per Bamford Adish, JSC, as she then was, Clause 1 of Article 2 gives standing to any person who is a citizen to seek an interpretation and enforcement of the Constitution in furtherance of the duty imposed on all citizens to defend the Constitution under Clause 4A of Article 3 and Article 41B. It is clear then that Clause 1A of Article 2 is a special jurisdiction available to citizens of Ghana only, irrespective of personal interest. Also, Akufu JSC, as she then was, in the same case stated that every citizen of Ghana, by virtue of such citizenship, has an innate interest in the integrity of the supreme law of the land, the national constitution. Therefore, there can never be an officious bystander or busybody. Every Ghanaian is and must be an interested party. Contrast the capacity in Article 2 to Clause 1 of Article 33. This is the end of Part 1 on the topic of constitutional interpretation. We hope to catch you on the next video. Thank you very much for staying with us all through the video. And kindly remember to subscribe, like the video, turn on your post notifications, and share to everyone as we continue to bring you quality, educative, and informative content. Thank you.